thing about Juan Galt. He's not a troll. He's a well thought out, and most of his responses are well thought out.
Well, thank you, Mark, for that surprise introduction. I wish I could return the compliment, but our subject for this part is one of your internet lawyer sacred cows of your spoonerism religion. Now, if this subject isn't the most ridiculous thing Stevens promotes, it sure as hell is close. And I can't believe people buy into this particular nonsense. It not only shows how lacking Stevens' legal knowledge is, but just how gullible his victims are. This bullshit makes Stevens' victims look foolish to the court, as well as having diminished mental capacity to understand legal proceedings. I'm talking about Stevens' ridiculous unsigned guilty plea. Anyone who has ever heard Stevens, hear me now. This tactic is as worthless as internet lawyer spoonerism. There's no such thing as an unsigned guilty plea or an intention to plead guilty. You either plead or you don't. And you don't plead on a piece of paper. You plead to the court, openly and verbally, for the record. This unsigned plea is not proof, it's not admissible evidence, and it's not a plea. It's just more Stevens internet lawyer bullshit. It's all about selling for Stevens. Now this is the fantasy that Stevens sells his victims.
Monkey wrench in the works is take advantage of some of their rules. So I have this will be available on the website as a template. It is an unsigned plea of guilty. And what it says is, I, Marc Stevens, enter this plea of guilty. The nature and cause of the charge and proceedings have been explained to me, and I am knowingly, intelligently, and voluntarily pleading guilty and waiving my right to appeal. Now that has to be there in a general sense. Most of the rules want that. And you have to sign it. So when we go in and the judge says, all right, Mr. Jackass, my little peon, my piece of property, you, how do you plea? Say, well, you know, I intend, and you hand him a copy of this. You got to have it in writing. This is now going to be evidence against this lying charlatan. You see, my intention is to plead guilty. Has the prosecutor, and you don't give him any chance to respond to this. My intention is to plead guilty. Has the prosecutor presented any evidence to prove the Constitution and laws of the plaintiff's state actually apply to me and that there's jurisdiction over me? The reason why we're doing this in writing also is because the judges, once you object and you call him on his nonsense that jurisdiction's a trial issue only, what a stupid thing, they're going to lie again. To get around the lack of evidence that the prosecutor is supposed to have, they're going to lie about you refusing to plea, even though it's in writing right on his bench, right on his exalted 4-foot wooden throne. That's why we do it in writing, because there's only two circumstances where the judge is permitted to enter a plea of not guilty, even over your objection. One, if you're refusing to plea. Two, if a plea can't be ascertained. Once again, it's a plea of guilty, so you can clearly ascertain what I'm trying to plea. You can clearly see the evidence is there. It's right here. I'm not refusing to plea. What he's doing is he's lying that you're refusing to plea to cover up for the prosecutor's lack of evidence.
Now this is the reality when Stevens' bullshit plea is used in court.
So, do I have the right to plead guilty here today?
You do.
Okay. Can I make an informed plea here today?
I don't know what that means. I don't
Well-
know what an informed plea is. Pleading guilty, you will be waiving all of your constitutional rights.
Mm-hmm.
Pleading guilty to a criminal traffic offense of failure to obey the lawful command of a law enforcement officer, and 2 civil traffic offenses of no registration and no insurance. Those are civil. And there's no possibility that you go to jail, but there is a very real possibility that I would impose a fine on you. So, That's what a guilty plea would result in, okay? Plus the responsible plea to the 2 civil charges. You don't have to do that. You've got a perfect right to say, Judge, I'm not guilty, I want my day in court, I want a trial, and I am offering to provide you a lawyer free of charge.
Well, sir, I'm willing to plead guilty. I have been. I have a plea of guilty with me.
Okay, no, see, you don't have the plea.
I do have the plea. It's
From the
right
county
here.
attorney?
Huh? I gave her a copy. She has it.
No, you've got it backwards, sir. Could you put that lid down? It's hard for me to see it. You've got it backwards. If you're pleading guilty, you're pleading guilty to me.
Uh-huh.
Right?
Yeah.
And it's not on a form that you create. It's what's known as a plea to the court.
Yeah.
It's not on a form that you create. If you're pleading guilty by way of an agreement with the county attorney, it's on a form that is generated by the county attorney. And it's the result of an agreement, a discussion that you have with the county attorney. If you're pleading guilty to me, it's not on your form.
Well, I made a form just to show my intention.
That's not the way it works, sir.
I'm just trying to make my intention
I realize
clear.
that, but I'm telling you, it's not the way it works.
Okay, you heard it. It's not the way it works. You've got it backwards. At best, Stevens' unsigned plea might be considered a conditional plea, or at worst, a diversionary stall. Either way, it's not an acceptable plea. Every defendant at arraignment is considered not guilty and remains so until they plead guilty or are found guilty at trial. So you see, when the judge enters a plea of not guilty for a defendant, he's not practicing law from the bench or violating due process. He is simply declaring what everybody knows. You're not guilty until proven otherwise. Now, here's another Stevens ranting sales pitch.
So there's evidence of collusion between the judge and the prosecutor, or if there's no prosecutor, between the judge and the cop. That judge is so desperate to put you on trial, he will assume the burden of proof on an essential element of the crime, including, which of course is jurisdiction. Because an essential element of the crime is going to be the applicability of the Constitution and laws, because that's what the courts are enforcing. That's what the courts interpret or declare. It's all about the Constitution and laws. There's no evidence that applies to anybody. So that's what he's going to do. He's going to lie. And it is a lie. And you need to object. I would object right away. Call him on it and say, excuse me, I know enough that you've got 2 situations where you can enter a plea on my, over my objection. When I'm refusing and when you can't ascertain. Do you need another copy? Do we need to go through this again? I'm trying to plead guilty. So, and you call him, I said, well, I think what you're doing, sir, is you're being dishonest and you're assuming the burden of proof for the prosecutor. You're lying to cover up the prosecutor's obvious lack of evidence. And more than likely, he's just going to, in a fit of rage, he's going to just set it for, he's going to enter the plea and he's going to give you a pretrial date. Now, this is a huge due process violation and a violation of fundamental fairness, because that goes into number 2, and it all ties in. So we've got lying about you pleading. So if you're going to do a motion to strike the plea, which I suggest, and to change the judge, you have to show a bias that arises from an extrajudicial source. Well, if he's lying to cover up for the prosecutor, it looks like it's from a political source. So it's not it is extrajudicial. Something's going on here. And you have to show that the bias is so great that you cannot get a fair hearing or fair trial. Well, if he's going to lie about you pleading to cover up for the prosecutor's lack of evidence, I think we've established sufficient grounds that this psychopath should be removed, disqualified, should be in jail, should be in one of the prisons that he sends his victims to. So that's a huge due process violation, which leads into point number 2, which is a huge due process violation, fundamental fairness. What he's doing is, when he is assuming jurisdiction, by assuming that the Constitution laws apply and he has jurisdiction over you, that is an element of the crime, because you're always charged with violating their code, their laws. Well, the applicability of those laws is an essential element of the crime, especially if it's something like growing plants out here, where it's a crime in name only. It's just because some politician said so. So it has to be proven beyond a reasonable doubt, and it has to be proven with evidence that the Constitution laws apply to then be able to prove beyond a reasonable doubt you violated it. So you're showing that the judge is assuming the burden of proof of the prosecution, that the prosecutor has to prove every step of the way jurisdiction. He has to prove at trial beyond a reasonable doubt. This evidence has to be there. He doesn't have to present it and put his witnesses on the stand and whatnot, but the evidence has to be presented to lead a reasonable person to believe that the Constitution and Code apply, and the court then has jurisdiction. So he's assuming jurisdiction on behalf of, this is an essential element of the crime, at the arraignment, within 2 minutes of walking in, up to his wooden throne, which leads us to major due process violation number 3. The judge is required, not the cop, not the prosecutor, not the clerks, the judge and a future jury, if there is one. They're the two parties that are required to presume you innocent of every element of the charge. Okay? Now that includes the applicability of the code, because again, logically, you can't prove the code was violated until you first prove that the code applied. So what the judge is doing by assuming jurisdiction on behalf of the prosecutor, who has presented not one shred of evidence, he is refusing to presume innocence. So this is something you object to, and you call him out on. I say, excuse me, am I presumed innocent here? Remember, to have a fair trial, they have to presume you're innocent until proven beyond a reasonable doubt. So you ask him, objection, am I presumed innocent of every element of the crime, yes or no? Oh, I am? So you're not presuming that the Constitution and laws apply to me. Now, I've had hearing officers and I've had judges actually say that they were not assuming that the Constitution laws applied, which gets them into a pretty tight bind. How can you assume that there's jurisdiction to even hold me here for an arraignment if you're presuming the Constitution and laws don't apply? That's the basis of their jurisdiction. So we can prove the fact that he's setting it for a pretrial. We can prove that he's not presuming you innocent, and it's impossible to get a fair trial when he's not only refusing to presume innocence, but that he is actually assuming the burden of proof on behalf of the prosecution. These are 3 major due process violations and fundamental fairness violations, all within 3 minutes or less of walking up to his wooden throne. So we're just getting started here. Now, you don't even really have the time to get into some deeper issues because he's going to throw you out. This cycle is going to throw you out. So what you're able to do is file a motion to strike the plea and disqualify the judge, because obviously you can't get a fair hearing from someone who is lying. And how do we prove he's lying? I didn't refuse to plea. He's obviously covering up for the prosecutor. And we file a motion to vacate and disqualify the judge.
Well, again, there's a lot of bullshit and lies to unpack from that Stevens rant. Stevens is basically setting up his victims so they will need to file his motions. Cha-ching. He pushes this unsigned plea, which invariably leads the judge to enter a not guilty plea, because the judge is required by law to enter the plea when the accused delays after being informed of the charges and consequences. And to continue to talk about intending to plea or attempting to question the judge about jurisdiction is reason enough for the judge to enter the plea so that all issues can be presented at trial. Stevens then uses this opportunity to sell a motion to strike the plea. Cha-ching, and remove the judge. Cha-ching. Unfortunately for Stevens' victims, the grounds Stevens claims, the judge lying about the plea, is just more Stevens' internet lawyer bullshit and appeal to the emotions of his victims. The judge is not taking up the prosecutor's burden of proof of jurisdiction. The prosecutor has none. It is the judge who is the one that must conclude from the pleadings whether there is jurisdiction or not. The prosecutor need not add anything else for jurisdiction. Jurisdiction is not an essential element of a crime. Stevens is lying. Likewise, applicability is not an element. Another Stevens lie to his victims. By lying to and confusing his victims, Stevens creates the opportunity to sell more motions based on Spooner gibberish. Cha-ching. More internet lawyer misrepresentations by Stevens. Stevens makes a big deal out of the plea because he doesn't want to go to trial. Why? Because at trial, Stevens' victims would have to produce evidence that the Constitution and laws don't apply to them and that there's no jurisdiction. And they cannot. Stevens tells his victims that there are 3 reasons why the judge has violated due process: lying about the plea, assumes jurisdiction, and refuses to presume innocence. My God, this is so stupid. First, the judge is not lying about the plea. The use of Stevens' unsigned guilty plea is a diversion and a stalling tactic. Trying or intending to plea is not pleading and could be considered refusing to plea, especially after the judge reads the charges and explains the consequences. Stevens is just psychopathically lying and appealing to the emotion to sell his motions. Since the judge is not lying, there is no violation of due process. Oh, by the way, fundamental fairness and due process are synonymous, but Stevens, the internet lawyer, is just too ignorant to know this. Second, the judge is not assuming jurisdiction. His jurisdiction has been authorized by the power of the state, a fundamental political issue, not a legal one. Nor is the judge assuming the prosecutor's burden of proof. Stevens is lying again because the prosecutor has met his prima facie burden. This is basic law 101 stuff. Stevens is further lying when he claims that the jurisdiction and applicability are essential elements of a crime. He is purposely confusing his victims regarding the prosecutor's burden and what evidence establishes jurisdiction and applicability. The only evidence required to prove the existence of the authority granted by the political power of the state is the law setting out that authority. Period. Instead of the truth, Stevens feeds his victims spoonerism bullshit, and they eat it up. The problem is, courts don't recognize spoonerisms as evidence of anything. Jurisdiction and applicability are 2 subjects that are separate and apart from the essential elements of a crime. Jurisdiction has to do with the court's authority to hear the essential elements of the alleged crime, and applicability has to do with the political power to apply enforcement. There are only 3 essential elements of a crime, and Stevens ignores informing his victims of this fact. The 3 elements are mens rea, actus reus, and concurrence. By having his victims chant his nonsense in court, Stevens is causing his victims to look foolish and exhibit diminished mentality. Since the judge is not assuming jurisdiction or the prosecutor's burden, there is no violation of due process. And finally, third, and this is the most stupid one, the judge does presume Stevens' victims innocent of the charge. And that's proven by the not guilty plea the judge enters on their behalf. It's amazing that Stevens can sell this particular bullshit to people in the 21st century. No wonder they sound retarded to judges when they spout such gibberish. But hey, Stevens gets to sell another motion. Cha-ching. Caught you in more lies, didn't I, Stevens?
Yeah, okay, yeah.
Go home, folks. Go home, folks.